I think our listener may wish to compare two sounds. They can be the judge or forensic musicologists themselves after this podcast. So they can go to any of the streaming platform, try these two sounds. One is the sound called He's So Fine by a group called Chiffons. Another sound is called My Sweet Lord by the former Beatles, George Harrison.
In 2023, the average person spent some 20.7 hours listening to music each week, including more than 8 different genres of music. Over 700 different genres have been given as the different types of music people listen to, reflecting the diverse music landscape that global fans now enjoy. Let's listen to the following conversation, which highlights the many factors behind the categorization of our favorite music genres, and so much more. Hello, Page Points listeners. It's great to have you join us and to share our discussion about copyright and music borrowing. The editors, Enrico Bonadio and Chen Zhu of the book entitled Music Borrowing and Copyright Law, a genre-by-genre analysis, they're here with us today. You will have already met Enrico during a previous Page Points episodes on IP and food. Welcome to you both to the podcast.
Thank you for having us.
Thank you.
Let's begin with our first question, in which music genres are often seen as fluid rather than in rigid categories. What are some of the biggest challenges in defining and categorizing music?
Yes, the music indeed are fluid, so it's harder to define and categorize. Legally speaking, I think the music copyright law is really multi-layered for defining what is music. So in the past, there have been two types of definition about what music can be under law. So one is a symbolic representation of music, so which represents music as symbols. So this was, I think, mentioned as early as in 18th century by the Lord Mansfield, who happened to be one of the greatest British judge, who made a ruling on a music copyright case in 1777 in a case called Bach versus Longman. So the Bach, not the Johann Sebastian Bach, but Johann Sebastian Bach's youngest surviving son, who went to the UK and stayed there until his death. So the J.C. Bach. And this established music and the law as kind of marks and figures types. So basically, in 1777, we know music can be protected under copyright law as a matter of sheet music, not yet sound. Another way of defining music is defining music as a sonic artifact. So this came a bit later. Interesting enough, it was not until 2005 in the UK we have another case in the Hyperion and the Sorkin, and the judge at the Court of Appeal, he defined music as a sound. So that's really interesting, to define music as a sonic object. So we really have these two way of defining music. So in that 2005 ruling, nowadays we can define music legally not just as the written down music symbols, as sheet music. It can be also recorded music. So long as you have some way of fixing your music, that's fine. In terms of categorizing music, I think it is even more fluid because there are so many music genres, categories nowadays. I think Spotify is very keen on cataloging all sorts of the music genres. If you go to a website called Every Noise, so they catalog how many thousands of music genres, categories. So many genres die each day or each week, many more emerge. So I think the challenge of doing a book, edited book like this is how to have many music genres manageable. So some music genres are more established, like hip hop. Some music genres, they didn't stand the test of time, so they die. But we try to have some music genres that can be representative. They have relevance in music copyright law.
Yes, if I may add, music genre classification faces several challenges due exactly to the fluid nature of musical categories. For example, the classification of music into genre is inevitably subjective, leading to inconsistencies in how different people categorize the same music, and this subjectivity makes it sometimes difficult to establish clear, universally accepted definitions for genres. Also, many genres share similar musical features, making it very challenging to draw distinct boundaries between them. And this is an overlap which can result in ambiguous classifications, especially for music that blends multiple styles. Then also there is an evolution element because music genres are not static. They emerge, evolve, and change over time. So new genres appear and existing ones evolve, transform, making again it challenging to maintain, let's say, up-to-date classification systems, right? Also, geographical factors may influence music genre, right, leading to different interpretation and categorizations across regions and culture. Also, technological influences are important because the rise of digital platforms in the latest decades, algorithms for music discovery and recommendation has introduced new ways of categorizing music that may not align with the traditional genre classification.
Yeah, so very broadly speaking, we are looking at these three what you call mega genres, meta genres. So they can be art music, folk music, and pop music. So these are three big ones. So they may overlap. So there are a lot more subgenres. So as you mentioned, a lot of genres are fluid. I think, for example, the genre called city pop. So what is genre city pop? So it is a genre which was popular in the 1980s in Japan. Now, after 2010, so there are kind of become global phenomena thanks to the kind of YouTube algorithms recommended to people. So yes, so I think the genres, they just evolve. Yes.
Throughout history, how have different cultures and musical traditions approached the idea of musical borrowing and reworking?
I think throughout history, I think this is a cross-cultural phenomena. Music borrowing is as old as music creation. So since the very beginning, when people will start to make music, they will borrow elements from different places. So I think in terms of law, I think the law tends to use this much more kind of simplified binary classification for music borrowing. So legal or illegal, infringement or non-infringement. But in the creative process in history, there are just a wide range of borrowing activity happens. So law is simply not nuanced enough. So thankfully, we have Professor Peter Buckhold, who is a kind of founder of the music borrowing in this field, who had a very detailed chapter charting the typology of music borrowing. So there are many, many types of music borrowing. I think lawyers can learn a lot from that chapter. That's in chapter 2.
Yes, as Chen said, the musical borrowing has been a common practice since ancient times. Classical masters frequently, incorporated elements from other works into their compositions, and folk music, traditional music, is a best case study, right? In many cultures, folk music has evolved through a process of oral transmission, no? Where melodies, lyrics have passed down across generation and naturally modified over time. So this organic form of borrowing has been crucial in shaping cultural identity. Another example could be Afro-American music, the development of genres like blues, jazz, gospel, always involved a complex interplay of African musical tradition and European influences. Slaves in America, no, brought from Africa, West Africa, created new musical forms by combining their African heritage with the music that they encountered in the new environment. So global influences cross-fertilization of musical ideas from continent to continent, also as a consequence of migration waves, has always been key. Cultures have come into contact through trade, colonization, migration, and the musical borrowing has followed in the footsteps, right? We have several examples that are reflected in our book, right? Migration. I give you just a short examples of how rap and hip hop developed in New York, in the Bronx. According to many commentators, DJ Kool Herc, a Jamaican migrating from Jamaica to the Bronx in New York, brought to the new town, New York, this idea of toasting, talking on the records, which was typical of Jamaican traditions. And this is the way hip hop, started in the Bronx in New York. So migration and borrowing, evolving, is a foundation of the birth of many music genres.
One thing from the books, so most borrowed music are not litigated. Only a small number of them, unfortunately, go to court. But these small number of the cases, they attract a lot of media attention. So yes, most music borrowing are innocent, so they will have no legal issues. And also another thing is I want to say, music borrowings may happen across different genres. So pop, art music, folk music, they borrow from each other. So think about the Mahler's Symphony Number 1. So Mahler had borrowed nursery rhymes, Frank Jacques, into his Symphony Number 1, and he turned it into the minor key, which is the brooding, long, meandering, a bit spooky, but it's a fun borrowing. So it had no problem at all. It's well accepted. And also, I think those 8-bit video music on composer like Koji Kondo for Nintendo. So I think he was influenced by the city pop music. So if you listen to early city pop group called T Square, there's a soundtrack called Sister Marian, and you listen to Brother Mario. So you will hear some similarity, but it's a kind of innocent, kind of paying homage to the early composer or songwriter.
There is also just a little criticism of borrowing, especially when what is borrowed is traditional music from the global south by Western, organizations. There is here an issue of cultural preservation because, of course, some societies, especially in the global south, have been more protective of their musical heritage, viewing sometimes borrowing as a potential threat to cultural authenticity, especially when this borrowing is made by Western organization for commercial purposes, right? And this has led sometimes to debates about cultural appropriation and the ethics of musical borrowing, right? We should also remember this aspect of borrowing as well.
How does copyright law balance the protection of originality and allow for music borrowing as an inherent part of artistic expression?
Yeah, that's exactly the copyright law tried to tackle. It's a $1 million question. So it's going to be very hard for copyright lawyers and judges in the courts because there's no ready-made formula the court can use. So then when they say they find that there are 6 or 8 sequential notes being similar or identical, therefore infringement. So there's no such thing as if similarity, then infringement. So all the cases have to be examined, adjudicated on the case-by-case basis. There are basically, I think, the 2 types of music similarities which concerns the court. So which I think the court will use to find out whether there's a copyright infringement. The first similarity is called a probative similarity. So it is just a fancy word for the kind of similarity will help the court to see there's a copying. So causation between the defendant's work and the plaintiff's work. So the probative similarity is used for the purpose of establishing inference of copying. So when the copying is established, this is not the end of the story. So the court will still need to go one step further by finding out if there is a substantial similarity. So substantial similarity is a similarity that will finally lead to copyright infringement. And sometimes, I think a lot of times the court will spend a lot of time with the existence of those music experts, which we'll talk a little bit later to find if there are these two types of similarities. So in my own chapter, I argue the substantial similarity is ontologically unstable, because in order to find the substantiality from the earlier music, you basically need to do a lot of work. And a lot of times, this is not like when a musician writes a song. It's more or less clear the song is written, so it's a piece of the music work which can get copyright protection. Say, for example, if you ask Beethoven, Mr. Beethoven, I like your Symphony Number 3. It's a wonderful piece. Beethoven may well agree. So because the Symphony Number 3 is the one which has its textual boundary, which when it was written, it is defined. But if you ask another question, Mr. Beethoven, what is the substantial part of your Symphony Number 3? This is going to be a much more difficult question, because nobody knows until the music piece got litigated. Yes, it is subject to litigation.
Yes, I mean, copyright law aims to, or at least should aim to, balance not the protection of originality with the allowance for musical borrowing, right? Which, as we have seen, is a fundamental aspect of artistic expression. However, achieving this balance is difficult. Of course, there is the fair use doctrine, right? In the US, fair dealing in Europe, UK. As many know, this is a legal principle which allows limited use of copyrighted material without permission for purposes such as criticism, commentary, education, parody. It provides a framework for assessing whether borrowing constitutes infringement or permissible use. But as I said, it's difficult to draw the line between legal inspiration and, on the other hand, illegal appropriation, let's say. Let's say musical borrowing spans a continuum from subtle inspiration to direct copying, let's say. And many cases fall in the gray area where it is difficult to determine the legality of borrowing. Also, the analysis is often subjective, no? And contested in court. And we need also to take into account technological advances. So digital tools in the latest decades make it easier not to replicate and manipulate music, complicating further questions of authorship and originality. We will talk about later about sampling and remixing, which are common in genre, about hip hop, electronic music, and they have often in the past faced the legal challenges, despite the fact that they're creative practices, right?
It is sometimes a bit harder to show this similarity, substantial similarity leads to infringement without giving concrete example. I think our listener may wish to compare two sounds. They can be the judge of forensic musicologists themselves after this podcast. So they can go to any of the streaming platform, try these two sounds. One is the song called He's So Fine by a group called Chiffons. Another song is called My Sweet Lord by the former Beatles, George Harrison. Listen to these two songs. In the court ruling, the judge identifies two places where the musics are substantially similar, where he called is the motif A and motif B. Motif A is a sol mi re, which repeated again. Then the motif B is 6 notes, sol la do la re do. So the re being a grace note, so which also repeat again in both pieces of music. So that's two places of the similarity. So eventually established infringement in this case. So there's a clearly melodic similarity, but in some other cases, like in the blurred line cases, there was no melodic harmonic similarity. So it's just a similarity where the vibes or feels of the music being similar. So that's why some cases can be more controversial than others.
Thanks, Chen. I'm going to take you up on that suggestion and have a listen. Could you please explain what is meant by forensic musicology and what challenges might exist when distinguishing inspiration from infringement?
Okay, that's a great question. Forensic musicology is a relatively young field, so it was not widely used a few decades ago. Basically, forensic musicology is used to assist judges to do music analysis, because most of the judges are not musically trained. They are legally trained, so they are very knowledgeable about the law, but it is not their profession to do music analysis. Although I know some judges, they do music, they are musically talented, but to do proper music analysis, you still need the forensic musicologists, so expert witness, to do this work properly. And most of forensic musicologists, I think they belong to a small group of people at the moment. So it is not widely understood. So it is a small circle. So it baffles a lot of people as outside. So I think the forensic musicology is really the field which needs more study. In our book, we have 2 chapters dedicated to this topic by 2 very eminent forensic musicologists. The first one is Guy Prothero. He practiced forensic musicology in the UK for the past 35 years. It was quite phenomenal. And because of the book, we end up knowing Guy quite well. And he turned out to be such an erudite, knowledgeable, and friendly person. And after pandemic, I invited him to give a lecture to our students to explain how he used his forensic musicology for the court. Another forensic musicologist who contributed to the book is Professor Joe Bennett, and he's a professor from the Berklee College of the Music. And he had a lot of important insight in this field. So, for example, in the chapter you mentioned the independent creation hypothesis, which needs to be tested. So both are practicing forensic musicologists, so we learn a lot from them in terms of the music borrowing.
Yes, I mean, as Chen said, forensic musicology is a relatively recent field of study. Is the scientific study of music in a legal context, primarily used to analyze similarities between musical works to determine potential copyright infringement. It involves applying musical expertise to investigate whether a song or just a part of a musical work is copied from another one, an earlier one. And musicologists, forensic musicologists, use techniques, specific techniques such as musical comparison, prior art research, audio sample authentication to assess the similarities. There are challenges, of course, in distinguishing, for example, inspiration from infringement, and such challenges lie in the subjective nature, no, of music and creativity, as we have said.
Yes, echoing Enrico what said, so there is a challenge to forensic musicologists, and these 2 contributors, they are not complacent about this practice, because there can be a lot of issues. For example, forensic musicologists need to be impartial, need to offer kind of objective evidence to the court. But a lot of the time, because the forensic musicologists are paid by a client, so it is very difficult to argue against, so provide evidence which is not in favor of their clients. So that's something worth thinking about. So how to avoid the forensic musicologist expert become overly adversarial. So they should have their impartial position. Another problem I've been thinking about for a long time is the validation of forensic musicology methodology, because if we do not validate their messages, so there can be good evidence and bad evidence. So if we don't have the proper validation scheme or method, it is very difficult to tell the bad evidence from good evidence. So it is a bit like my analogy is a tea leaf reading. So some people go to a fortune teller, so they will have tea together. So after tea, they will look at the teacup, look at these leftover tea leaves. The fortune teller may tell you, oh, it looks like a dragon or like a snake. So next month you will have good or bad luck. So human beings are very good at interpreting symbols, or very good at over-interpreting symbols. So sometimes you will see forensic musicology providing fancy kind of music score comparison diagrams, but with no kind of third-party validation. So that's a danger. So I think for future reference, I think a lot more research need to be spent in this field to validate the forensic musicologist methodology, how valid, how good they are.
What are the ethical and legal implications of artists incorporating traditional music into their own projects?
Yes, I think although traditional music are called traditional music, a lot of them may have identifiable authors. So they can be composed, so-called traditional music, and they can also be rearranged music, which may trigger new copyright. I think one of the telling case from the book, and also something we know a little bit already, is the Lion Sleep Tonight case. So because the Disney film used that song, of course, it become very, very popular and famous. That song is adapted from an early song called Mbumbi, which was recorded in 1939 by a Zulu African worker who happened to be very talented. His name is Solomon Linda, but he was not treated very well by the copyright system. And he was illiterate, and he signed away his copyright. And his family, after Linda's death in 1962, living in abject poverty. So that's a very, very sad story. So I think the ethics issues, I think that if someone want to adapt or use so-called traditional music, they really need to do diligence search to find out someone who might have contributed to compose this piece of music, and they deserve copyright royalty. So what happens later, I think there is a South African lawyer. He wrote a piece in 2006 for the WIPO magazine about the litigation, how he managed to repatriate the copyright back to the Linda's family. I think that's a very interesting case, which used the copyright law to help a traditional music composer. But it's a very difficult, long legal journey.
Yeah, adding up on ethical considerations, of course, artists, musicians, they must consider whether their use, for example, of traditional music shows respect for the source, culture, and its heritage. As I said before, there is a need to recognize potential imbalances, no, between the borrowing artist and the source community, especially when Western artists borrow from global South traditions. So that's important. In general, artists should consider how accurately they represent the borrowed traditional elements and whether their use might lead to misrepresentation or stereotyping, which might be disparaging sometimes. So, ethical borrowing often involves properly crediting the source of music and recognizing its cultural significance. That's important. Sometimes it doesn't happen. This is no good, of course.
How does the idea of a musical unconsciousness help to explain recurring patterns in pop music?
Yes, when you say the music unconsciousness, I think this can be divided into two issues. One is a creator's unconsciousness. So sometimes the creators may borrow unconsciously or subconsciously from the early source. So that happens in the case we just mentioned, in George Harrison case. So it was established that George Harrison borrowed subconsciously, although he didn't have the intention to borrow, but he just regurgitated from something deep from his unconsciousness. But unfortunately, the copyright law uses strict liability. State of mind doesn't matter. Ignorance is not a defense. Even someone unconsciously copy from an earlier source, this will still be copyright infringement if there are substantial similarity being found. Another unconsciousness, I think, comes from the listeners. It is the listeners' collective unconsciousness, because a lot of times listeners don't want to hear overly original, overly new music. They want to hear something familiar, something nostalgic. So that's why it explains the kind of revival of the city pop music. So people want to go back to the past. So I think that there is a big market for those kind of nostalgic, familiar music. So that's why the place where the music borrowing come in. So in order to work for that market, the musician got to be very, very careful. So if they borrow, they need to make sure they don't borrow kind of substantial part from the early music, and also they need to acknowledge that they are sourced properly.
Yes, I mean, the concept of musical unconscious often helps explain recurring patterns in pop music, right? By, for example, highlighting the role of unconscious process in both music creation and perception. For example, it may suggest that composers and listeners are influenced by musical schemes, cultural experiences, and also psychological factors that operate below the level of conscious awareness. And these can lead to the emergence of common chord progressions, melodic motifs, rhythmic patterns across different songs and artists. So the musical unconscious also shapes listeners' expectations, making certain musical structures feel familiar and satisfying to the ear of listeners. Additionally, this concept of musical unconscious suggests that repetition and familiar patterns in pop music may be linked, right, to the brain's tendency to seek, to look for efficient ways of encoding and remembering musical information. And this happens, as Chen said, in the famous George Harrison case. So even if you don't realize it, you may be a copyright infringer because subconsciously you have reproposed the musical elements, right? That have somehow somewhat entered your brain.
But also, I have seen the argument saying that unconscious copying or substitute conscious copying should be a defense, but it's not yet being accepted by the legal system. So we will see how this will go in the future.
This makes one think about hip hop, which has long been built on the practice of sampling. How has copyright law shaped this genre's evolution?
Yes, hip hop is really interesting because it is based on a lot of sampling. I think one of the turning point for hip hop is the 1991 Grand Upright Music versus Warner case. So where Bismarcky, this rapper, borrowed music from O'Sullivan's Alone Again. So basically, in that court ruling, the judge says you really need a license in order to do sample. I think that's established and one very important precedent. But looking back many years later at this case, I have sympathy for both sides. From the Bismarck's point of view, this is the way hip hop artists have been doing for a very long time. They use sampling quite often. So that's a way of making art. From the claimant's point of view, O'Sullivan's point of view, that song called Alone Again was a poignant song written for the loss of his parents. So he didn't want this song being used, quote unquote, in a comic sense. So I think there are some more rights issues, but this was not raised in that case because the litigation proceeding was brought in the United States, and the United States didn't have the more rights for musicians, although they have some more rights legislation for those visual artists, but not for musicians. But if this case happened in the UK, there might be an issue called the moral rights of integrity. So the authors will have the right to stop the works being kind of derogatorily treated, which is prejudicial to his or her honor or reputation. So I think the moral rights issue also needs to be, I think that people need to be aware of that when borrowing.
Yes, exactly. I mean, the hip hop music here gives us a perfect case study to assess how sampling and how copyright law has impacted on the evolution of hip hop in general, because most cases, most interesting cases, come exactly from hip hop. As Chen already said, the Grand Upright Music case of 1991 has been a landmark case establishing that unlicensed sampling constitutes copyright infringement, requiring artists to obtain permissions before using even very short samples. Another important case was Bridgeport a few years later, another case involving hip hop, involving sampling. And interestingly, in these two cases, judges clearly said, get a license or do not sample. Very clear. And in the first one, actually, the judge said, you shall not steal, quoting one of the 10 commandments, all the commandments. So it is clear from these two cases that the judiciary in the US especially has been very, very strict in preventing, follow-on artists from appropriating even just very tiny, very short samples. Of course, there have been criticism about this, strong copyright enforcement, with someone arguing that the strict copyright laws have discouraged creativity in hip hop. by limiting the ability to freely borrow and transform existing words. However, other commentators have, on the other hand, pointed out that these restrictions encourage innovation by pushing producers, hip hoppers, rappers to create original sounds or at least reinterpret samples in transformative ways. Because under US law, fair use is allowed when the second comer transforms the meaning of the borrowed, in this case, the borrowed music, right? In Europe, we also had more recently a case, which is the Pilam case, originating in Germany. And again, here, the Court of Justice of the European Union took a pro-copyright stance in the sense that it required basically the license of a previous sample, right? Especially if this sample is still recognizable to the listeners. So again, if you as a sampler, as a hip hopper, are able to transform the sample in a way which is no more recognizable to listeners, well, you can get away with that. So similar but not identical ways of interpreting the fair use in this field in the two sides of the Atlantic.
In electronic dance music, where remixing and sampling are essential, how do artists navigate copyright restrictions while maintaining creative freedom?
I think in terms of EDM, electronic dance music, so the same rule applies, just like the hip-hop music. So nowadays you must clear your rights for when doing sampling. I think that there are also new EDM genre emerging these days, for example, algo rave. So the algorithmically composed dance music. So I know there's a community who are very enthusiastic about using a software code, doing live coding for dancing. For example, one of my favorite coding software is called Sonic Pi, which is designed by Sam Aaron. So it's a wonderful piece of the software which allows people to do live coding for EDM. But I think that community has no issues with music borrowing. But of course, I can imagine issues. So if people get the code from, say, GitHub, so I think that they need to look at the license, make sure that they need attribute to the original author. If the code was not licensed and an open source license, just make sure there can be compliance issue.
Yeah, as Chen said, here very similar issues arise, similar to the hip hop scenario, because again, EDM, electronic dance music, is very much based on sampling, remixing, mashups, and so on and so forth. So artists here, they need to seek permission from copyright holders to use samples. And these can be very time consuming and very expensive, especially for lesser known producers, right? I mean, the big producers, the big creators of EDM, they might have the financial capabilities of going through this minefield of copyright holders and stuff. But what about less known EDM producers? And let's remember that EDM can also be created in bedrooms or in living room with these very powerful machines that now are available to many, are very affordable, right? And just to conclude on this, we also need to specifically consider that the peculiarity of EDM lies in the fact that the boundary between record production, sound recording production, and music composition is practically non existent here. There is a kind of merger between underlying musical composition and recording experience, because both dimensions are fully integrated into one single progress. And this blurs the original distinction between song composition, which is basically written by a songwriter, and recording in the studio. EDM basically merges the two experiences.
I think Enrico is right, because I think that there's a kind of blurred line between composition and performance. So how can someone tell when people doing live coding, is it a composition or performance? So probably both.
I would like to take this opportunity to thank you both for sharing your time today and for highlighting the different aspects of your book. This book, as you said, is filling a potential gap in the scholarly practitioner sphere in relation to music borrowing. Not only am I pleased to be able to highlight that this book is housed in our knowledge repository, but also that this year's World IP Day theme is IP in Music, Feel the Beat of IP. So the availability of your book is very timely to help contribute to that discussion and celebrate everything that that entails.
Thank you so much, Liz, for having us. It's been a pleasure as usual.
Thank you. It's been a great pleasure.
The pleasure is mine. Thank you. I hope that you enjoyed my conversation with Chen and Enrico about music borrowing and copyright law. The book includes a carefully selected range of musical genres, including pop, hip-hop, jazz, blues, electronic and dance music, as well as a diversity of region-specific genres. There's something for everyone. Until next time, and the next page points, bye for now.